Alright. As far part 4 of the UCC connection, Howard Freeman. Gonna finish this on off. Where was I at? How the UCC 1-308 works. Hold on, man. Shit, I got the washer and the dryer popping in this motherfucker. Anyway. The U.S. Constitution establishes the court's jurisdiction as common law, equity, and amorality under Article 3. As opposed to this, the federal corporation establishes a similar jurisdiction under the Uniform Commercial Code. Hold on. My fault. Okay. As opposed to this, the federal corporation establishes a similar jurisdiction except under the Uniform Commercial Code. See UCC 1-303, Supplementary General Principles of Law applicable. Unless displaced by the particular provisions of this Act, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, or other validating or invalidating cause shall supplement its provisions. Anytime you see law by itself, as in the foregoing, it means the common law, except that they are taking the common law jurisdiction from the UCC from the contract UCC. The remedy, of course, is UCC 1-308. So the UCC is a deceptive criminal contractual constitution of sorts to those who use it against us. UCC 1-308 is the remedy for any legal process under the commercial law in the United States. UCC 1-308, performance or acceptance under reservation of rights. A party that with explicit reservation of rights performs or promises performance or asserts to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, or the like are sufficient. Since the federal corporation is just that, a corporation, it has no jurisdiction except with those that contract with it. Also see Congressional Act of 1871 and 28 U.S.C. 3002. Part 6, Chapter 176, Subchapter 176, Subsection A. 15, United States means a federal corporation. Excuse me, I got this good ice cream over here, man. So hold on. Where was I at? Okay. The states illegally contracted with the federal corporation bypassing the Uniform Commercial Code, making themselves, as well as the unsuspecting people, subject to the federal corporation and also to the states in their new commercial capacity. The Uniform Commercial Code creates the corporate state of the United States, the federal corporation, as opposed to the several de jure states of the Union. UCC 1-201 General Definition. State means state of the United States. As opposed to the several states of the Union, USC Title 28, Part 6, Chapter 176, Subchapter A, 302. Definitions 14. State means any of the several states. Because the states accepted and passed the Uniform Commercial Code, they converted state citizens into persons, legal entities, articles of commerce, and the states into vessels of the United States, placing the states and state citizens under maritime law. See the brilliant wordsmithing in the following. I ain't about to let out my ice cream just melt like that though. So give me a little second here. Look at the strawberries, brother. USC Title 18, Part 1, Chapter 1, 9. Vessel of the United States defined. The term vessel of the United States as used in this title means a vessel belonging in whole or part in the United States. No, in part to the United States or any citizen thereof, or any corporation created by or under the laws of the United States or of any state, territory, district, or possession thereof. Therefore, all laws, color of law are contractual commercial laws, and the remedy is UCC 1-308. The Uniform Commercial Code makes all crimes commercial only by contract as per 27 CFR 72.11. The problem is that only the higher courts will recognize the remedy. However, the remedy should legally and always be given without delay on demand or claim. This, of course, is the problem. The misdemeanor courts do not have a clue as to whether their jurisdiction comes from, and neither to where their jurisdiction comes from, and neither do magistrates. You have to get in front of a court with a real judge that tries felonies. Man, this ice cream melting real fast. Can't do that, man, you know. I mean, I'm gonna complete the video, but she ain't no motherfucker watching this motherfucker right now, know it. Chocolate, you feel me? That's my favorite chocolate. Alright, this is the last one. Damn, I knew I was gonna get something on my shirt. I don't know nothing about these though. Okay. The courts try to string you along under duress of threat, hoping that you can be scared into a plea, but in the end they have to honor the remedy. 27 CFR 72.11. Disposition of seized personal property. Table of contents. Subpart B. Definitions commercial crimes. Any of the following types of crimes, federal or state: offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale of or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame, and like offenses, extortion, swindling, and confidence games, and attempting to commit, conspiracy to commit, or propounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. 1938. April 25th, the Supreme Court overturned the standing precedents of the prior 150 years concerning commercial law in the federal government because there is no longer silver and gold coin as Article Section 10 of the Constitution. Article 1, Section 10 of the Constitution. There is no federal common law, and Congress has no power to declare substantive rules of common law applicable in a state, whether they be local or general in their nature. They be commercial law or a part of law of torts. Erie Railroad County versus Tompkins, 304 U.S. 64, 82 L edition, 1188. The common law is the founding resource of substantive remedy and legal and remedial rights, if not our very liberties. The members and associates of the bar thereafter formed committees and granted themselves special privileges, immunities, and franchises, and held meetings concerning judicial procedures, and therefore to amend laws to conform to a trend of the judicial decisions or to accomplish similar objectives, including hodgepodge, hodgepodging the jurisdictions of law and equity together, which is known today as one form of action. See Constitution and Bylaws, Article 3, Section 3.3c, 1990 through 91, Conference Book, also Colorado Methods of Practice, West Publishing, Volume 4, pages 2 through 3, Author's Comments. 1939 ABA, American Bar Association, gets more involved in approval of uniform law products. 39 acts are presented to the Board of Governors of the ABA for consideration and approval. During the same year, all acts on aeronautics and motor vehicles are established, as well as the Land Registration Act, Child Labor Act of 1930, Uniform Divorce Jurisdiction Act, Firearms Act, Marriage Act, and more. 6 acts are reclassified as model acts. 1940, at the start of the decade, after deletions, etc., 53 acts out of 93, which had been approved since the group's founding, remain on the books. Drafting Committee for the Uniform Commercial Code, UCC, approved. 1941, speaking of the Commercial Code Project, the conference president states, "This is the most important and most far-reaching project on which the conference has ever embarked. It would take the major part of the next 10-year period to complete." 1942, the UCC effort begins in earnest with completion of the work on Revised Uniform Sales Act. 1933. My file, 1943. Members of the conference participate in the drafting committee in Washington, D.C. to work on legislation which the government might desire in connection with the war effort. No new acts. 1944. Conference receives $150,000 grant from the Falk Foundation of Pittsburgh to support work on the UCC. 1945, no actual meeting for the first time due to difficulties of civilian transport during the war. 1946, Falk Foundation support of the UCC with an additional $100,000. 1947, Uniform Law Conference, ULC, the American Law Institute, ALI, joined in partnership to put all the components together for the UCC, Uniform Divorce Act approved. 1950, approval of the Uniform Marriage License Application Act, Uniform Adoption Act, and the Uniform Reciprocal Enforcement of Support. May 18th. During a joint meeting with the American Law Institute of Washington, D.C., the UCC was approved. Later that year, the ABA formally approved the code as well. Considered the outstanding accomplishment of the conference, the code remains the ULC's signature product. As one of the uniform laws drafted by the National Conference of Commissioners of Uniform State Laws and the American Law Institute governing commercial transactions, including sales and leasing of goods, transfer of funds, commercial paper, bank deposits and collections, letters of credit, bulk transfers, warehouse receipts, bills of lading, investment securities, and secured transactions. The Uniform Commercial Code, UCC, has been adopted in whole or substantially by all states. See Black's Law 6th edition, page 1531. In essence, all court decisions are based on commercial law or business law with criminal penalties associated with it. Rather than openly calling this law admiralty maritime jurisdiction, it is called statutory jurisdiction. Senators own Congress. They own the executive. They own the judiciary, and they own all the state governments. Do you have a birth certificate? They own too. Last note: the 14th Amendment creates a lower class of citizen of the United States rather than the high class of citizens. Remedy provided to the 14th Amendment is an act by Congress known as 15 U.S. Statute at Large, July 27, 1868, one day before the 14th Amendment took effect, also known as the Expatriation Statute. This is your remedy to claim to being a natural citizen of your state. This makes you a higher citizen and no longer subject to the Article 4 loophole that deprives you of your rights. Gone is the self-evident truth that all men are created equal. The Uniform Commercial Code is a private international law that is owned by undr. Does the UCC apply to you? The body of learning we call conflict of laws is called private international law because it pertains to private interests, while public international law pertains to relations between states. Garner versus Teamsters, Chauffeurs and Helpers Local Union, 346 U.S. and 74 Supreme Court 161. In the sense of public international law, the several states of the Union are not foreign to the United States, nor are they foreign to each other, but such is not the case in the field of private international law. Robinson versus Norato, 71 Rhode Island, 256 43A, 2D 467. The Uniform Commercial Code, by the copyright owner's own admission, is private international law. In other words, the 50 United States of the Union are publicly united with each other while privately foreign to the United States. In other words, private international law pertains to private interests, and public international law pertains to public relations between states. To simplify the events that cause the confusion of public is private and private is public, we include the following. The first connection from the highest potent position is that A77 statute 630 through 631, PL 88 through 243, 1963, and PL 88 through 244, 1963, make the Uniform Commercial Code, UCC, private law for the municipal district, expressly affect citizens of the federal government. 77 statute 630 through 631, PL 88 through 243 is an act that enacts the Uniform Commercial Code for the District of Columbia and for other purposes. This is where the UCC functions as the law of the land for the federal government, District of Columbia, and territories. For sake of simplicity, public law, PL 88 through 244, is private law for private corporate citizens and not for the people. Private law is confined to particular individuals, associations, or corporations. 50. And law can be enforced by a court of competent jurisdiction when statutes for its enforcement are 20 undr 33 pages 58 and 59. 3. Statutes creating corporations or private acts 20 undr 35 page 60. 4. In this connection, the Federal Reserve Act is private law. Federal resistance and corporate power from the Federal Reserve Act are Federal Supplement 674, 1979. 5. The distinction between public acts and private acts is not always sharply defined when published statutes are printed in their final form. Case versus Kelly, 133 U.S. 21, 1890. B. It is all private law and international law, but may be referred to as private international law, and it is owned by the same people that own public law. 88 through 243, 1968. The UCC was written and is owned by undr, International Institute for Unification of Private Law, which is located within the Vatican about 100 yards from the Holy See. And 1. To properly address public law, one must understand that a private corporate charter owns public law. Converted to public policy in 1938. Policy equals political equals police. All private corporations, fictions, including governments, are under public policy and can only deal with other corporations, fictions. 2. Private man is not affected by public law, private law, or public policy, as long as private man does. We only got a couple pages left. Public means of concerning or affecting the common unity of people, the assemblage of private men. 4. Private means not available for public use, control, or participation, belonging to a particular person or persons as opposed to public or the government. Remember, as a corporation, the government becomes no more than any other corporate person. Not holding an official or public position. 5. The entire taxing and monetary systems are hereby placed under the UCC, the Federal Tax Lien Act of 1966. C. The U.S. pays $260,000 per year to undr for the use of the copyrighted UCC. The International Registry is the private law of undr, and since the United States has signed onto the undr statute, the International Institute of Unification of Private Law, all of which is incorporated herein by reference in its entirety, which is all about private international law, which is another name for the Uniform Commercial Code. On page 6, legislative activities, the first item is principles of 5 Benelux Treaty on Compulsory Insurance and Civil Liability in Respect of Motor Vehicles, and 1958 Convention concerning the recognition and enforcement of decisions relating to maintenance obligations towards children. Hague Conference on Private International Law. undr is owned and operated by the Vatican, and they intend to enforce their religious ceremony on the millions of people of the land in America and elsewhere in the world. This is further proof that the corporation called United States is owned and operated by the Vatican to further their agenda, and they are using their commercial law to enforce their martial law. No law compels the private sector non-governmentally non-governmentally privileged work-eligible women or men to submit a W-2 or W-9 form or their equivalents, nor to obtain or disclose a Social Security number as a condition of being hired or of keeping his job. With the exception of an order from a court of competent jurisdiction issued by a duly qualified judge, no amounts can be lawfully taken from one's pay for taxes, fees, or other charges without the worker's complicit, intentional, knowing, voluntary, written consent. This is the manner of enforcement which gives Title 42, 1983, its unique importance. For enforcement is placed in the hands of the people. Each citizen acts as a private attorney general. Enunciation. Frankenhauser versus Rizzo, 59 FRD 1973. Section 9, Assassination. 148. The law of war does not allow proclaiming either an individual belonging to the hostile army or a citizen or a subject of the hostile government slain without trial by any captor any more than the modern law of peace allows. Such internation should follow the murder committed in consequence of such proclamation made by whatever authority. Hey, that's hard. Let me try. I had to get my pencil out so I can note that right there. I like that. That's what niggas needs to know right now. Civilized nations look with horror upon offers of rewards for the assassination of enemies as relapses into barbarism. The laws of Congress in respect to those matters do not extend into territorial limits of the states, but have force only in the District of Columbia and other places that are within exclusive jurisdiction of the national government. CAHA versus U.S. 152 U.S. 21, 1894. Under the laws of commerce, truth is sovereign. The foundation of the Uniform Commercial Code, UCC, is commercial law. The precepts and truths. The basis of commercial law is the law of Exodus of the Old Testament, i.e. the Ten Commandments, and the Judaic Orthodox Hebrew commercial law of Moses. The laws of commerce unchanged for at least 6,000 years from the basis of Western civilization, if not all nations of the world. Therefore, commercial law applies universally throughout the world. Commercial law is non-judicial. It is prior to, superior to, and the basis of, and cannot be set aside or overruled by the statutes of any government, legislature, governmental or quasi-governmental agencies, courts, judges, and law enforcement agencies, all of which are under an inherent obligation to uphold said commercial laws. Commercial law is the war of truth expressed in the form of an intellectual weapon called an affidavit. An affidavit is simply a written list of facts or truths signed under the penalty of perjury and usually notarized. The person making and signing an affidavit is called the affiant. That's the truth. The 10 maxims of commercial law. 1. A workman is worthy of his hire. Exodus 20. Verse 15. Leviticus chapter 19, verse 13. Matthew 10, chapter 10, verse 20. Chapter 2, verse 6. It is against equity for freemen under the law. Exodus 21, chapter 21, verse 23 through 25. Leviticus 26, verse 17 through 21. Deuteronomy 1, verse 17 and 19, verse 21. Matthew 22, verse 36 through 40. Chapter 10, verse 17. And I don't know, whatever call is, chapter 3, verse 25. I can't think of what is that right now. No one is above the law. Commerce by the law of nations ought to be common and not be converted into a monopoly for the private gain of a few. 3. In commerce, truth is sovereign. Exodus 20, verse 16. Psalms 117, verse 2. John 8, verse 32. And 2 Corinthians 13, verse 8. To lie is to go against the mind. Oriental proverb, of all that is good, sublimity is supreme. 4. Truth is expressed in the form of an affidavit. Leviticus 5, 4 through 5. Leviticus 6, 3 through 5. Leviticus 19, 11 through 13. Numbers 30, verse 2. Matthew 5, verse 33. And James 5, verse 12. Number 5, an unrebutted affidavit stands as truth in commerce. 1 Peter 1, verse 25. Hebrews 6, verse 13 through 15. He who does not deny admits. 6, an unrebutted affidavit becomes judgment in commerce. Hebrews 6, verse 16 through 17. Any proceeding in court, tribunal, or arbitration form consists of a contest or duel of commercial affidavits wherein the remaining points not rebutted in the end stand as truth of the matters to which the judgment of law is applied. A matter must be expressed to be resolved. Hebrews 4, verse 6. Philippians 4, verse 3. And Ephesians 6, verse 19 through 21. He who fails to assert his rights has none. 8. He who leaves the field of battle first does not respond to 10, verse 22. He who does not repel along my phone right now. Junior, let me call you right back. Okay, still going. This is the last little bit. He who does not repel a wrong when he can occasions it. Number 9, sacrifices the measure of credibility. Acts 7, life, death of Stephen. He who bears the burden ought to derive the benefit. One who is not damaged or willing to swear an oath on his commercial liability for the truth of his statements and legitimacy of his actions has no basis to assert charges or claims and forfeits all credibility and right to authority. A lien or claim can be satisfied only through A, rebuttal by counter affidavit point by point, B, resolution by, or C, payment or performance of the claim. Genesis 2 through 3, Matthew 4, Revelation. If the plaintiff fails to prove his case, the defendant is absolved. Because truth is sovereign in commerce and everyone is responsible for propagating the truth in all of their speaking, writing, and acting, all commercial processes function by affidavits certified under oath to be true and correct, not misleading and complete. On each affiant's commercial liability regarding all matters stated and likewise demanded. In written matters, on nearly every document that those who run the system desire that you sign your signature as presumed to be under the penalty of perjury. In a court setting, however, testimony and oral commercial affidavit is sworn to be the truth, the whole truth, and nothing but the truth, so help me God. The participant must provide material evidence, i.e. ledgering, bookkeeping, proving that each fact or entry is true, valid, verifiable, and relevant. Without the sense of liability in support of one's assertions, no credibility is established. That was the UCC connection. It's a little skinny book, man. But it took 4 hours to read on this motherfucker. One of them like 66 pages though. But shit, now it's on video, I can just listen to it without having to read it over and over. Cause it's just easier for a motherfucker to listen to some shit, you feel me? But that's it for this one. Like it, share it, send it up. Message it to your friend. It's Fresh Out West, America Best. Subscribe to my channel.